Welcome to the Champions League finals of arbitration discussions today. We're very happy to host the World Arbitration Update for the first time in Budapest. If I wanted to be very corporate, which I have to, it really closely aligns with our values and our actual aims business-wise. We really want to show the region that Hungary has really first-rate arbitration practitioners, and they can actually make other people who are much better than us to travel here and be with us for this very special occasion. We very much hope that this is going to be a tradition, and I very much hope you're going to have a fabulous weekend without any atrocities meeting the 100,000 English football fans who just descended on Budapest. Thank you.
Is this working? Okay, well, David, thank you very much for hosting the World Arbitration Update. For those of you, which are most of you who don't know who I am, my name is José Antonio Rivas, and I am a Washington, D.C. lawyer who does investor-state arbitration. I also teach public international law and investor-state arbitration at Georgetown, and have a boutique practice on precisely that: investment arbitration, public international law, and international commercial arbitration. But most importantly, what I do is we have founded or co-founded with another fellow who is Ian Laird from Crowell & Mooring, which you might have heard of. We had co-founded the World Arbitration Update 6 years ago, and the whole thing started after we had before again co-founded the Washington Arbitration Week, which already has 7 years in the run, and it's actually thus far well known, and it has grown in numbers and sponsorships, etc. But the important thing is that one day we received a book or I received a book on fair and equitable treatment by a lady from Sri Lanka, and it was fair and equitable treatment in developing countries. And then the question to me was, and I read it, and it was actually very well drafted and so on, and now she's an arbitrator in various forums, but at the time she wasn't. And my question was why is this lady not here in DC, and why isn't she in London, or why isn't she in Paris, and so forth? So the question became quite existential in terms of the center of arbitration is not only Washington, D.C. The center of arbitration is not only Paris or London or New York. And that sprung a question which was we have to go beyond the main centers of arbitration and try to give a platform to everyone. And thus, so far, we have been in various places. The only continent that we haven't been to is Australia and New Zealand. We have been in China, we have been in New Delhi, we have been in Poland, we have been in Madrid, in Bogota, in Mexico, and the list goes on. So the idea is twofold. One is to decentralize international arbitration. And by that we mean to give a platform, because it is growing, and no matter what we want, it is growing, and there's incredible practitioners in the 4 or 5 continents, and the conversation should be one wide, worldwide. Incredible practitioners, arbitrators, quantum experts, etc. And the other objective of the World Arbitration Update is to precisely update on issues of public international law, international commercial arbitration, and investor-state arbitration. So that's why we're here. This year, we decided to only do it in three places. And actually, I have a lot to thank to Bálint, because he was sort of like the brain behind making this the last venue of our week of World Arbitration Update. We had been speaking about doing it in Budapest, but he set it up, and also in conversations with David, he made it happen. So, thank you very much on that. This week we have mainly focused on international investment arbitration, public international law, and climate change. Those have been topics that have been addressed both in Bogota and then in The Hague yesterday, and today in Budapest it's not solely focused on climate change, but it has key questions. One of the international rule of law, the first panel, and it has key questions of enforcement, namely the second panel. Okay, so that's it. So welcome. Thank you very much to DLA Piper for the hosting. Without you, it wouldn't happen. And thank you for those that are watching online, and for those of you who are here. Okay, and now I'll sit down and talk as a moderator. Okay, thank you.
Excellent. Thank you. Thank you, everyone, for coming out on this beautiful afternoon to Budapest. Thanks for those who are online, who logged in to hear us speak. So I'm going to be presenting the first panel. I'll be introducing the first panel, and for that purpose, I actually have typed up some remarks on the Energy Charter Treaty, also because I don't want to go over time, but I also don't want to mention some of the details that will be later discussed by our esteemed panel. So the Energy Charter Treaty, as historically, right, it has been enforced since April 1998. It was established to foster cross-border cooperation, trade, and investment in the energy sector among its 53 contracting parties, which included 51 sovereign states, the European Union, and Euratom. In the post-Cold War era, it is often repeated, the treaty's primary objective was to secure Western investment for Eastern European energy markets by offering robust legal guarantees, non-discriminatory treatment, and, in case of disputes, investor-state dispute settlement. In the past 3 decades, the Energy Charter Treaty evolved into the most heavily litigated investment treaty in history, with a significant portion of its caseload consisting of disputes between initiated by EU-based investors against EU member states. As global priorities shifted from fossil fuel-reliant energy security to climate change mitigation, the broad protections the treaty provides to fossil fuel infrastructure have increasingly been viewed as incompatible with the green transition or with broader frameworks such as the Paris Agreement. This fundamental conflict initiated a modernization process in 2017 at the level of the Energy Charter Treaty that would align the treaty with decarbonization targets. However, the modernization efforts failed to prevent a fragmented legal landscape, ultimately leading to a coordinated withdrawal of the EU and Euratom and a series of unilateral exits by several EU member states. The exit of European Union member states continues, but it is not the principal cause of the mentioned fragmented legal framework, legal landscape. In the long line of investor-state arbitration cases in which the EU has expressed its opinion, I want to highlight one specific moment, which is in March 2018 and the Slovak Republic versus Achmea case, in which, in its ruling, the Court of Justice of the European Union essentially held that investor-state arbitration clauses in bilateral investment treaties entered into between EU member states were actually incompatible with EU law. The court reasoned that such arbitral tribunals operating outside the judicial system of the European Union could not refer questions of union law for interpretation to the Court of Justice via the preliminary reference procedure. This, it was decided, threatened the autonomy of EU law, its uniform interpretation and application. Although Achmea focused strictly on bilateral treaties, the Court of Justice extended this reasoning to the Energy Charter Treaty in September 2021 in the Republic of Moldova versus Komstroy case. In a narrow interpretation of the Energy Charter Treaty, the court held that a debt derived from a mere commercial electricity supply contract did not constitute protected investment. That was the main question that the court had to address. But in addition to addressing this question, obiter dictum, the Court of Justice ruled that Article 26 of the ECT must be interpreted as inapplicable to disputes between an EU member state and an investor of another member state. Building on this, it was argued that this ruling meant that, from the perspective of EU law, the offer to arbitrate under the ECT was invalid ab initio in the intra-EU context. The rulings of the Court of Justice of the European Union also made clear that any intra-EU investment arbitration awards were incompatible with Union law and consequently could not be enforced. This judicial campaign succeeded in influencing at least one EU-seated tribunal, in the case Green Power versus Spain, a tribunal at the Arbitration Institute of the Stockholm Chamber of Commerce, dismissed the investors' claims under the ECT for lack of jurisdiction, directly applying the Komstroy judgment. Conversely, ICSID tribunals operating under a self-contained treaty system, but also other tribunals outside the European Union, continued to assert jurisdiction, rejecting the reasoning of the Court of Justice of the European Union and creating a deep systemic conflict. This is currently the situation. Judicial rulings and official interpretations are insufficient to stop ECT-based intra-EU arbitration. It is now proposed that member states withdraw from the ECT, and at the beginning of this year, the European Commission initiated infringement proceedings against 16 member states, urging them to withdraw. Withdrawal, however, leaves us with a further challenge, that of the survival or sunset clause of the ECT. According to this, the treaty's provisions continue to apply to investments made prior to the effective date of withdrawal for an additional 20 years. To prevent investors from utilizing the sunset clause to lodge their claims, the EU and 26 member states out of the 27 executed a joint declaration in June 2024. This declaration contains their common understanding that Article 26 of the treaty does not and never did apply in intra-EU relations, rendering the sunset clause inapplicable to intra-EU claims. This understanding was formalized in September 2025 when the European Parliament and the Council adopted a decision approving this inter se agreement on the interpretation and application of the Energy Charter Treaty within the EU. However, this is still not sufficient to stop claims from being brought or to stop the enforcement of awards that were handed down in the meantime. This invalidation of the ECT within the European Union has resulted in a deep global divide. Award creditors continue to seek enforcement in non-EU jurisdictions, while courts within the EU block enforcement of intra-EU awards. Courts in the United States, Australia, or the United Kingdom have consistently rejected EU law-based sovereign immunity defenses, applying general rules of public international law instead. This is, of course, merely a brief overview of the situation. Several questions arise as a consequence of this mentioned legal rift. What will happen to claims in intra-EU disputes going forward? Will there be a viable and comparable forum for claims brought by EU investors against EU member states? will the standards of treatment of foreign investors typically included in international investment agreements find their equivalent in other dispute settlement regimes? And how will damages be calculated if other fora are addressed with such questions? Some of these questions and even more will be explored by the upcoming panel. And then I give the floor to the moderator, José Antonio, to take it forward. Thank you.
Thank you, Bálint. And Bálint, trying to be very, very timely, jumped, and I haven't introduced him, which is necessary. You might all know him, but those online might not. And also for the record, I should. So I'll try to be quick on this. But before introduction, there's the context of where we are is one which Bálint quite rightly posed the question of, will there be a forum for dispute resolution of investment disputes related to investors versus EU countries, EU investors versus EU countries. I mean, that's one question. That's a key question. The other question that is also quite relevant is those cases or similar cases being enforced outside of the EU. The issue of enforcement outside, and as a context, just a few days ago, the U.S. government submitted its amicus brief to the Supreme Court, setting its position on the request by Spain on certiorari, which is the last recourse under U.S. constitutional law. So, this has been long-awaited position, and this is the position of the U.S. government concerning the request by the governments of Spain before the Supreme Court. So what did it say? What was the expectation? The expectation by Spain was that it would be its case or its cases would be heard by the Supreme Court, and it still expects that. But the position of the U.S. government carries a lot of weight because the Supreme Court may listen to it with a lot of attention. Now, it said many things, but I think that the key thing here is that one, it set its position as framing the arguments of Spain before the Supreme Court in two ways. One, it indicated that in contradiction to the Vienna Convention of the Law of Treaties, the position of Spain was one where it was attempting to apply domestic law, and it used the word domestic law to excuse its lack of compliance with international law. So when it referred to domestic law, it was referring to EU law, although it's regional law. And the other part that is relevant is that in arguing that there shouldn't be an agreement or there shouldn't be an arbitration, it also referred to the notion that in principle there was consent to arbitrate under the ECT, but he used the words apparently or not quite so now. So the argument of Spain is that although a member or full member to the ECT, it apparently is now arguing that it did not consent to international arbitration. So those two messages are quite strong. There's more to that, but the idea is not to focus fully on that. But you can see the tension between, on the one hand, international law, and the tension, on the other hand, EU law. Okay, and with that, I'll stop You can read it. It's very interesting because in many respects, the WOW has been following the Komstroy, and full disclosure, I was co-counsel in the enforcement of Komstroy in the US. As you know, the beauty of this panel is that we have also had counsel, or we have or former counsel for some cases in favor of the EU position. So all of that is here in this table, which to me is amazing. In any event, I would like to stress or present everyone, and I hope that I'll be quick. So Bálint Kovács is an assistant lecturer of the Faculty of Law and Political Science, University of Szeged, where he teaches international economic law, private international law, and regional economic interaction. He has been teaching international economic law at Sapiencia, Hungarian University of Transylvania since 2017, and part of the reason he is here is because he does investor arbitration, and he has also researched and written about investment arbitration by small and medium-sized investors, which is an area that is very difficult in investor arbitration because filing small cases is difficult in such a system. So that's Bálint. And then next, Jadranka Jakovcic is also an expert on investor arbitration. She is both a common and civil law lawyer. She has advised states in both investor state arbitration and commercial arbitration with experience at ICSID. And she has also practiced in Croatia, Italy, Brussels, also at the European Commission. And she holds the New York bar. And she has also, I'm very grateful to Jadranka because she has, in many respects, being sort of an ambassador of World Arbitration Update in Eastern and Central Europe. And I could go on and on. And Sirshar Qureshi is in many ways a very strong partner of World Arbitration Update and Washington Arbitration Week. And one little anecdote, I mean, he's a quantum expert, and many of you may know him. Pretty amazing, but also very much involved in bringing knowledge, practical knowledge, to quantum experts, junior quantum experts, but also counsel. With Sirshar, the Washington Arbitration Week has launched a program that now it'll be the fourth year this year, where we have a workshop, practical workshop during half a day for counsel to learn from quantum experts. So it's basically a workshop where they have a case written by PwC, which Sirshar heads, and they learn to do the most difficult thing I think you could do in cross-examination, which is examining an expert, a quantum expert. It's like examining the one person that knows way more than you when you're a lawyer. So it's quite, yeah, at least quantum-wise. And I haven't read your bio, but I think that's very important. David Kőhegyi.
I give
There
you
you go. Yeah, there you
on
go.
a scale of 5.
Oh, good, very good.
You're getting better.
Okay, good. 4.5, good. So David helps in. Well, he's your colleague and maybe also your partner or your senior partner, etc. He helps clients in resolving international disputes, regulatory problems, and high-profile international investigations. He has a particular expertise in investor state arbitration and over 15 years at DLA Piper. He has built a practice recognized as the leading one on the Hungarian market and among the preeminent ones in the CEE region by numbers of investment disputes. He has represented corporate and individual clients in human rights claims before the European Court of Human Rights and advises on public international law issues such as sovereign immunity and treaty negotiation. He represented Hungary in the renegotiation of the ICSID rules and has been on the ICSID panel of arbitrators since 2020. He is dual qualified, registered as an attorney in both New York and Budapest, and holds degrees from the University of Miskolc and the University of Michigan Law School. And last but not least, Professor Crenguța Leaua.
10.
Oh, there you go. So, Professor Leaua really brings the perspective of the EU to the table, and that's what I would emphasize. These are complex issues, and one of the things that we try to do in this forum is really have a conversation between the different fields of international law or regional law, and that is important because without that conversation, it would be very difficult to ultimately understanding and eventually hopefully creating solutions. So Professor Leaua is an experienced international arbitrator acting frequently under various rules of arbitration, including ICSID and WIPO, among others, and she is listed as arbitrator by various institutions across Europe and many other continents. And she is an arbitrator and she is a vice president of the ICC International Arbitration she's a vice president of the ICC International Court of Arbitration, a member of the ICC Commission on Arbitration and its task forces on climate change and construction law, and she has been recognized as a thought leader in international arbitration by Who's Who since 2017. As founding partner of Leaua Damkali LDDP, it ranked among SCAR's top 100 international arbitration firms. She has a PhD from Bucharest University and has completed executive education at Harvard University and a blockchain and cryptocurrency program at the London School of Economics. And she teaches on international comparative arbitration at the Bucharest University Faculty of Law. So with that, let's start our panel and substantive panel and our questions. The first question or the first topic is intra-EU cases continue to arise as set up by Bálint, and arbitral tribunals accept jurisdiction, and awards are or seem to be enforceable outside the EU. As we know, they may be enforceable. There have also been high courts in England and Australia and in the US, which have, despite what the EU has been saying, indicating that they are enforceable. So the question goes to David in terms of, is this an issue of law versus law? Is it an issue of regional law versus international law? Or is it an issue of supra-international law, being that the EU versus international law?
Thank you. Hi, everyone, again. This is a very complex question, and although Bálint did a really good job in this, let me try to do a little background story again here before I answer your quite focused question. Some of us on this panel have been arguing either or both sides. I had the pleasure of arguing both sides of the case, although with my esteemed colleague Zsófi and Fanny, we can say that half of our adult life was spent litigating Achmea on behalf of Hungary. Why tribunals still accept jurisdiction? And that's key to understand, to understanding the whole point that we're going to get to. Well, tribunals usually emphasize that Article 26, the dispute resolution clause of the ECT, and its paragraph 2, contains an unconditional consent to arbitration by contracting states. So they say that this consent is assessed under public international law and the Vienna Convention. Well, there are some tribunals, of course, who are also bound by EU law. Usually this comes up when it's an uncitral arbitration. But quite interestingly, when I researched last night, I found 2 ICSID awards. They're unfortunately non-public, so if anybody listens to this and you have it, please send it to me. It's SAPAC versus Spain and European Solar Farms versus Spain, dated exactly the same date, 11 October 2024. What's really interesting about this, according to a press release issued by Spain, I'm going to quote, is that it states that the participation of the EU in the ECT as a regional economic interest organization has introduced into its scope the supremacy of EC law in the field of competences transferred to the EU by the member states. So that's why they found jurisdiction, although I cannot avoid alluding to the issue that the esteemed David Unterhalter, the South African Supreme Court judge, was the president of both tribunals. And in one of them, Daniel Brennan, and the other one was Marcelo Cohen, who was sitting as the state's appointee. And as we all know, in arbitration, you need, if you're a 3-member panel, just need 2 to win. And of course, there were dissents, which are also non-public, to the awards. So I understand that these are being annulled. In the process of annulment, but I'm very much looking forward to the exact reasoning how Mr. Cohen and Mr. Unterhalter just got to the point. But going back to the line of reasoning why tribunals assert jurisdiction is that there's no intra-EU carve-out in the ECT. We all know that, so many tribunals find that the ECT does not exclude intra-EU disputes. And there's no textual basis for disapplying Article 26. I'm really trying to be not too detailed and not too boring in this one. But let's say that some courts of non-EU jurisdictions, such as Switzerland, they confirmed that the consent actually extends to intra-EU disputes. So the reverse argument. So therefore, they upheld jurisdiction in these cases. Now, again, the autonomy of arbitration and the competence principle is also important here because obviously tribunals decide jurisdiction as their own prerogative, and some arbitral tribunals rule that they're not bound by EU law, especially those who are sitting in sort of self-contained regimes, much like the ICSID Convention. And of course, there's this most interesting part, which we've been back and forth with, the fragmentation issue. If we group arguments into different groups of issues or legal issues, most tribunals actually openly accept the problem that a lot of international lawyers actually deal with, that international law is just fragmented, and there are various regimes apply to a particular problem, but there's no hierarchy between them, so they can be existing parallelly without conflicting results. And the key question is, from which perspective you view these cases when you assert jurisdiction as a tribunal, And if you look at it from the perspective of public international law and you apply the Vienna Convention on the Law of Treaties as a means of treaty interpretation, and you actually look at the treaty before you, which is in the context we're talking about is the Energy Charter Treaty and Article 26, then you cannot apply EU law in this process. So it doesn't apply, and so jurisdiction stands. Now, we get to the second issue here in order to answer your question, and that's why can we still enforce these decisions if there has been further developments since the Achmea and the Komstroy cases, and the EU member states themselves, at least 26 of them, declared that these are not enforceable and they're not going to enforce it, and the Commission is going after each and every member state that is being naughty and not playing by the rules set by the Commission, and of course the Treaty on the Functioning of the European Union and Article 17 of its annex. So why awards are enforceable? Again, because of the primacy of international enforcement frameworks. Because especially outside the EU, courts are going to look at two things. If they're under if the decision that they're looking at, or the award, is under the ECT regime, they're going to look at Article 54 of the ECT Convention. It's a self-contained regime, so they have to enforce, otherwise they breach national obligations. The other one is the New York Convention, if you're looking at UNCITRAL decisions. And these regimes actually both require the recognition and enforcement of awards as final and binding domestic judgments. And because EU law is not part of this framework, and the US courts actually confirmed it, and if they get cert, Spain gets cert, then we'll see how it plays out. But assuming that there is there's no competing jurisdiction within the US, because there's only one circuit that can deal with this, and because the United States District Court for the District of Columbia is the one that is actually dealing with all ECT cases under the ECT Convention Article 54, then probably, the outcome can be quite well predicted. But still, it's a due process issue, so they have to go through it. So the ECT obligations do not override EU-based objections. And then also some courts go as far as saying that EU law is irrelevant foreign law. Depending on how you phrase it, but non-EU courts actually treat EU law as either foreign law or an instrument that is absolutely irrelevant from the perspective of determining whether consent was valid or not. And therefore, they do not look at the CJEU's jurisdiction or jurisprudence in terms of deciding the dispute. And of course, one other issue was mentioned: sovereign immunity arguments. Because of the waived immunity embedded in the underlying multilateral agreements, namely the Energy Charter Treaty and the ECT Convention, usually domestic courts outside the European Union reject these sovereign immunity arguments. We've also seen this in New Zealand. Quite a thing to wake up to a hearing at which is 12 hours ahead. They cannot undo this waiver. So if you waive sovereign immunity as a state in a treaty that you sign and you become part of, and it becomes part of your legal system, then you cannot then undo a waiver through another instrument. Basically, I would stop here and turn to answering your question. And I would say that the short answer is of course, it's not so simplistic. You cannot answer with a yes or no. And I made up, I think, 4 criteria through which you can examine this problem. When we were in law school, the first thing that they taught us is you always answer if you're uncertain, say it depends. Well, it depends. But then this is more concrete here. First of all, let's look at competing claims to primacy. And that's, there's the EU law claim. Autonomy, supremacy, and exclusivity of CGU jurisdiction. And then there's the international law claim, which I alluded to in my longer than expected speech, is that there's pacta sunt servanda and the treaty obligations that cannot be unilaterally neutralized. So this is not just conflict. It's the mutual exclusivity, the claim to the mutual exclusivity of the various regimes. And it depends on in which regime you are sitting, you claim that supremacy. That's totally normal. So who decides? And that's the problem, because in some of our cases, we were trying to look at bodies or anything that can actually, that's the whole problem with fragmentation of international law, that you need to look for someone that is the ultimate decision-making body. Arbitration is a very funny thing, because it's not only that they don't have precedent, but they also don't have a supreme body that can actually make certain clashes between diverging decisions unified. So who decides? Who decides? The CGU says that, of course, they have the exclusive authority if EU law is implicated. And of course, then tribunals say that, we claim authority under, in this case, the ECT arbitration clause. So this is a classical jurisdictional overlap. And there's no one to decide, just the tribunals themselves. And because of competence, they're going to assert jurisdiction. Then, again, I alluded to this, but the issue of the systematic fragmentation issue. And there is and this is going to be, I think, a super important thing in the years to come. Those who are here from the Ministry of Foreign Affairs, they probably started going back to the history of the Vienna Convention from 1814. It's a pretty major thing, because what I see in international law and just general international relations nowadays is that the world is not only becoming fragmented from the perspective of international law, but from the perspective of political relations. And obviously, it's fully in the press, but we are probably back in the Vienna Congress days when there's going to be various regions, there's going to be various powers that are going to decide who is going to be participating in the resolution of a particular issue that is concerning that particular region. So I think in the rest of our adult lives, we're going to see these issues. And so fragmentation of international law is going to become even worse in that sense. And there are going to be various regions which are going to have diverging international law applied by them. So I think the Achmea and Komstroy EU law versus public international law problem is pretty much a structural issue and a structural decoupling problem for the years to come. And finally, the enforcement asymmetry that or asymmetry. Michael Ostrov's not here to correct my English, so inside the EU, obviously awards are often blocked, but outside they're enforced. The question is, if you advise clients, it's going to be, okay, do we have assets? And because arbitrations of this type tend to be quite long, for 5 years, any state who actually has negative awards against them are going to have a lot of time to remove those assets, unless they're types of assets that are very difficult to remove. So I think this is not merely international law versus EU law conflict. I think it's a structural confrontation between two self-contained legal orders, each claiming final authority over each other or over the ultimate decision of the problem. And I think that depending on who you're representing, there can be advantages or disadvantages to this, and you can use it to your advantage. But what we're going to see, I think, in the next decades is a situation that is even worse.
Indeed, the one effect that we can see out of the Komstroy and also I'll repeat. So one effect that you can see out of Komstroy and Achmea is the various regions are watching. So you see, for instance, some, I wouldn't call it a movement, but you see some Latin American states saying, well, if the EU can do it, why not us? So it does put some stress in international law, regardless of whether one is in favor of the Komstroy and Achmea sort of EU perspective and decision. It puts some stress and says, well, if they can do it, why not the Constitutional Court of Argentina, or why not the Supreme Court of Bolivia, and so on and so forth. So it does have a systemic effect for those that may put a lot of weight into or appreciation into the international rule of law. It does put some stress, and just as a sub sort of ethereal team, this is done in a time where the international rule of law is under a lot of stress, not only in international economic law, but in general, in international law, given the current state. But we won't talk about that because it's sunny today. So nowadays, I'd like to move with Jadranka, and I would ask you to address, whether the EU inter-se agreement entry into force has had any effect on the jurisdiction of tribunals, or whether we can expect that it could have some effects. There's various articles, them perhaps better than most, of the Vienna Convention on the Law of Treaties, 31.3c, 41, etc. So what are your thoughts on that?
Thank you, José Antonio. And just before I start, a quick thank you to you for bringing us all to Budapest. And thank you very much to David and DLA for having us today. I am going to address your question from more as a critique of EU stance. And then I believe we will hear. Is that better?
Oh, you have the mic.
I have a mic? Okay.
It's just for you. Oh, it's for me. Okay.
And then we will hear the opposing view. And I do have to make a small disclaimer that the position that I'm sharing here, obviously, as it was allocated amongst speakers, and does not necessarily represent my own view. Now, when we talk about what's happening post Achmea and Komstroy and where the tribunals seem to be heading, one of the most interesting aspects of this debate is it's not just a disagreement that relates to the ECT itself, but as we could hear from a very nicely put summary by David, there is a disagreement with regard to the nature of consent to arbitration under international law. And then there is a disagreement with regard to relationship between EU law and public international law. So David really walked us very well through where the conflict is between EU law and public international law. So I will not repeat myself on that. And that pretty much lays out the reasoning why tribunals predominantly keep rejecting intra-EU objection. But under the issue of consent or the outlook to consent to arbitration, the central issue is basically whether EU member states can, through inter se agreements, effectively neutralize or retrospectively extinguish consent to arbitration. And as we've heard, the stance of the EU is yes. However, the international tribunals seem to be going in the other direction, except for, I believe there is one case so far. It's the Green Power v. Spain that accepted the intra-EU objection. And there are several issues, and I will just briefly go through three main reasons why tribunals seem to be not receptive of that objection. So the first one, looking from the public international law perspective, is that the ECT is a multilateral treaty, which involves not only EU member states and the EU itself, but non-EU parties as well. And so from that perspective, many tribunals have considered that it would be really difficult for a subgroup of treaty parties to fundamentally alter the operation of the dispute resolution mechanism through such agreements. And that is particularly so where that may affect the treaty's object and purpose, and of course, the parties' expectations under the treaty. The second reason is arguments that tribunals seem to be repeating, which concerns Article 31.3a and 31.3c of the Vienna Convention. So Article 31 relates to the rules of interpretation. And what tribunals have repeatedly emphasized there is that subsequent agreements or relevant rules of international law cannot simply override a clear ordinary meaning of the treaty text. And that is particularly so where Article 26 contains a standing offer to arbitrate, which is also what the investors relied upon when they decided to make an investment. The other thing that tribunals keep repeating or keep emphasizing is that consent became perfected once accepted by the investor. And so in that sense, making a retrospective withdrawal, of course, would be particularly problematic from the stance of legal certainty and consent-based jurisdiction. Then the third one, Article 41, which relates to the parties, to the right of some of the parties under the treaty to modify a treaty. So that article is, or that ability to do such modification is also subject to limitations, and that limitation relates to basically such modification cannot be done in a way where it would affect the rights of other treaty parties, or again, as mentioned just a minute ago, undermine the object or purpose of the treaty. And so the tribunals predominantly consider that dispute resolution form forms part of a broader investment protection architecture of ECT, and thus making the EU position difficult to reconcile with the treaty's consensual framework. Now, in terms of the conflict of EU versus public international law. I am not going to get into that because, as I said, David made a really good job, which made my job much easier. But one thing that actually really I found curious, and we know that that's the position that U.S. court keep taking, is, I mean, it's such clear conflict, but Jan, you referred to it also as a regional law. And that's really, I mean, I see that as one of the main conflicts in terms of positions as to how diametrically conflicting legal systems are viewed from depending on where you sit, whether you are sitting intra-EU or outside of the EU. But these are some of the reasons that tribunals seem to be continuously relying when refusing intra-EU objection.
And thank you, Jadranka. And one approach, although I personally don't like, the whole discussion in international law between dualism and monism. I just, my thesis is very passé, but I think that the dualist perspective offers the understanding that these are different systems of law, and to that extent, if you understand that there are different systems of law, then you can understand that at some stage you might have a conflict and the impossibility of complying with both, which is called an antinomy. But ultimately, well, if it's the Court of European Justice, then you're in EU law. But if you're before the ICJ, you're in international law. So, and there might not be a solution. But beyond that, let's move forward. And I would like to invite Professor Leaua and with the following sort of thoughts in terms of one of the principal critiques of ISDS, principally the ECT. The other topic that we will be addressing is whether there should be arguments for and against, or there are arguments for and against concerning the EU perspective. I mean, quite openly, because this is a conversation.
Thank you very much, and particular thanks to the previous speakers who made my task, I would say, really hard, not to say impossible, because you are brilliant and you have actually presented both the general perspective, the context, and the arguments against the position of the European Union. But what I would try to do is, whatever it's to be done in a moment of difficulty, to become philosophical. So allow me to say two things that I feel that contributes to the overall understanding, and I will capitalize on your wise dilemma, whether it is important to look in a dualist perspective or not, and also to your initial question, where it is law versus law, and says the following: we are captured, all of us, in this discussion and in the dispute resolution system, in the binary type of thinking. And we are all captured by Aristotelic logic, where tertium non datur. We have either or, not a third option, either or. This type of thinking, in or out, international or national, being domestic or being foreign, everything that we put on table as arguments, we think into this perspective, which is pro and contra, for instance, all of them. And we are very much like programmators in a way. I love to tell my students that before having this paradigm of code being law has been a code in which we try to codify reality, which is very complex. when we say fragmentation nowadays, we say the same thing, but we still think binary because we are thinking like in a cubic thinking, in which bits and pieces are of the same whole. I'm looking now at the beautiful setting of Philip Piper here in Budapest, and I see the portrait of Rubik Ernő, who is the inventor of the Rubik Cube, which is a 3D basically puzzle system, in which the only way to look at the whole puzzle and to solve it is to understand what the ultimate destination is. And first of all, do it without actually looking at every single phase of the transformation. And I think that this is what we should do, to understand that whatever we are dealing with is a mix of colors, that the only purpose they have is for them to be put into a certain order that is specific on long term. I think we are in a process. We are in a process of achieving a goal. And in this process of achieving maybe the perfect Rubik Cube that will have only colors of a specific type, we are dealing with a reality which is too complex for us to process it in one color only and in this option. So what's happening because of that? It's happening the following. We are not allowing ourselves as lawyers to think in paradoxical terms. We are not allowing ourselves to think that both may be true, that it is international and national, that it is regional and of other type of definition. And whenever we define, we divide. And that is a logical problem that we are not going to overcome. The only way that we can overcome it is like with all paradoxes, to accept it and to move into a new reality in which both may be true. Now, where is the problem with European Union? And please, I'm not speaking for the European Union. As all my colleagues here, we have presented our position in different contexts, but I'm trying to understand the European Union. And I think this is the concept. We are dealing with new entities on international arena who have the right to define themselves and not to fall into the predetermined definitions that already exist. And if this is a new creature that is created in the international arena, it should have the right to define itself and have this identity issue solved in the way that it chooses to define it, not in the way that it is labeled. In the Roman era, we used to define the civil status by nomen, tracta, and fama. The way in which we define ourselves, in which we name ourselves, in the way the others are treating us, and in the way the others are speaking about us, the fama. Now, the most important thing is ignored here, how the European Union is defining itself. And that right, I think it's a sovereign right of the countries who choose to be forming this new entity that has its own personality, its own capacity. And an argument that it's often overlooked at the level of the position of European Union in terms of whatever is the effect of its identity is its capacity. So the member states' capacity in relationship with the overall capacity of the European Union in dealing with whatever their disputes inside. And without entering into many complex details of this level, I would simply state the three interconnected propositions that the European Union made in order to substantiate its position as to why it is incompatible to have the continuation of the bilateral investment treaties in the context of, or even ECT, in the context of the European Union Treaty. And the first one is that whatever is happening in such a dispute, it's affect the necessarily it's an interpretation of the EU law, which is an exclusive power of the European Union judiciary system. And the type of approach in which you ignore this reality and you say, well, they will not touch EU law, it's not a reality. It is a fantasy. In fact, it is touch always the EU law, either as a fact or as a matter of law by international tribunals in the investment system. The second, the tribunals are structurally, the arbitral tribunals, or external to the EU law system. They are structurally incapable of preserving the EU autonomy. So it is a conflict between how the European Union defined itself of having this kind of jurisdictional system that allows both prevention and dispute resolution, the package of two. And the package of two, if you look at them, you understand that you have the possibility to have preliminary requests to the European Court of Justice, which is a preventive system of the courts not complying with EU law. And this is something that, for instance, does not exist into the investment tribunal analysis on EU law matters. And that makes them completely incompatible with a new logic that is the logic that includes prevention and dispute resolution and not only dispute resolution. And then the next and the last one that I would like to mention is that we have a specific provision, which is Article 344, that requires member states not to submit disputes concerning the interpretation and the application of the treaties to methods of settlement that are outside those provided by the EU law. Now, what does it mean? It means that it is a matter of choice of the countries when entering into the European Union to decide to have this kind of exclusivity. They change their presence in the international dispute resolution arena by incorporating this type of commitment that they made. Now, if that is the situation, how we deal with the fact that the bilateral investment treaties were not effectively terminated in a way that is made formally present through bilateral documents? Well, we do what we can do, we adapt. So basically what the countries did, they moved into having this kind of terminations and then moving into having withdrawal from the ECT, and that these are steps to be followed in consistency with the new identity they assume they have. Now, if that we put the whole situation in this angle, I will not restate all the arguments. I have noted them down in order to present them, but I find more useful to ask a question and to ask ourselves a question. I'm not expecting for anybody to reply to it, but to which extent we may give more prevalence to the concepts of being obsolete or redundant, which are factual relationships and not to legal terms that are encapsulating this kind of legal relationships into the pre-existing notions. The obsolete situation is a situation when the reality changed and you cannot operate with the previous context. The redundant situation is when the situation multiplied in a way that you have somehow to deal with multiple ways for a specific situation that are not all of them equally effective, but you may look at them as coexistent. What do you do with obsolescence and redundancy in the concept of law? Usually we don't like that. We fight against those. But these are realities. They are economical and social realities in the context of this agreement. And for that reason, I would go back to some part of my background, which is new technologies. And I love to hear about decentralization of international law versus centralization of national laws. And that is something that ringed a bell into the blockchain community, by the way. Why? Because it is about a philosophy, and that's a political philosophy, that one may wish to look very carefully as being in tension, because centralization and decentralization are tendencies. They are like gravitation poles that are attracting the reality in two different directions. And if we don't think as equally existing, if we don't accept that both exist, it would be like us ignoring a reality that we cannot escape. And this is what the tribunals were forced to do. They were told, each of them, you have to live in the reality of this treaty, or you have to live in the reality of that treaty. The type of perspectives that you mentioned, it's absolutely true. But we are not living like this. We are just not living like this. And if we want to solve dispute resolution, if we want to make dispute resolution effective, we should accept to have this kind of hybrid approaches. And how these hybrid approaches will develop in the future remains to be seen. But to me, the situation is too complex not to give rise to new entities and not to give rise to new dispute resolution system for those new entities. I expect, in a positive way, not in a negative approach, for the, maybe, let's put it bluntly, the chaos to continue for a little while. But chaos, I don't know for which of you are familiar with ancient mythology. Usually the gods of chaos were also the gods of creation, most of them. So basically, we are watching the creation of a new era. You mentioned about the Vienna Convention new approach. Well, maybe not the Vienna Convention new approach, maybe the Roman law new approach. And the Roman law new approach, reinvented, would be used as art, equi and boni. Law is not a science. Law is an art. It's the only territory in which we can make paradoxes coexist, and we can escape from the complexity of the reality being fragmented, only integrating it through a different logic than the exclusivity logic, the logic of dichotomy, the logic of tertium non datur. Tertium should be welcome, not non datur. That's my point. Yes.
Thank you very much. 30 seconds, really.
You have 2 minutes.
One, I may be a little bit nerdy here, but you started coming up with the Rubik cube and the Roman Empire, and so I started making notes, and it's very, very good points. But here's the thing. First of all, the European Union itself. Oh, and by the way, this is not the LA's perspective, and not even my perspective. I'm just offering a absolutely reflection from a unique perspective to what you've just stated, which we all might consider. So I think the European Union was founded on the foundations of the Roman Empire. Somehow it's the historical evolution, you can tie it back to that, and of course with all the traditions and legal traditions and everything. International law itself, Hugo Grotius and everyone else, is a creation of this. Some argue that the EU was quite aware of, throughout the course of integration, when the Exit Convention was born in the 60s. The EU was all part of it. Every single, national regime was part of this creation, the creation of the multilateral world order with joint hands across the Atlantic. This whole thing, this whole idea of the problems with the fragmentation came out first after the Argentina cases, which started springing up the number of investment arbitration cases from the beginning of the 2000s. And then second, after May 1st, 2004, when the first 10 countries from the former communist bloc joined the EU. What some argue is what is a controversial thing in looking at it, and this is the nerdy thing, that you have two views of international law. The one is the holistic view, where you look at the entire system and there should be mechanisms that actually resolve these types of clashes. And then the fragmented view, which is more friendly and more appealing towards sovereignty and nationalism and all that stuff that the EU is fighting against. Now, to me and to so many people, it's kind of a it's a very interesting phenomena that the EU is actually, while it's advocating for a uniform Europe and for universal principles and universal international law, and is trying to keep the multilateral order in place, is actually advocating for the fragmented version of or fragmented view of public international law. To me, it's a very interesting thing. And Professor Berman was here for the Budapest arbitration days in András's panel, and it was quite interesting that he brought up the issue that the funny thing about the EU is that it's a project. Again, this is very important. I'm not making an advocacy here, and this is not my view. I'm just offering perspectives. This is Professor Berman's perspective, and that's that. There's no other international organization in the world history that has such a strong sense of that project and has the tools to assertively build up that project. And these problems that we actually face here are the product of that issue. And again, the key question: who asserts jurisdiction over a certain issue? And the EU wants to see. It seems the EU wants to see a world where multilateralism and international law is a good thing, But the moment when it doesn't serve the EU's purpose, it enters into these fragmented worldviews. It resorts to these tools that are usually a product of a fragmented world. So to me, this is the thing that needs to be resolved. And I'm really wondering if we look at this from a power struggle perspective. Again, we're back into the Vienna Congress, and I'm just wondering what the solution is going to be. But I fully agree with your perspective that we're actually seeing the creation of a new order, if I understood you correctly, and sooner or later, not so late, a entirely new system is going to materialize.
Let me. I know that the natural instinct is to respond, but I won't. Yeah, the natural instinct is to respond, but I won't let you. Because we have more in stock, and one, and you will be able to respond eventually. And I'm going to just throw a couple of questions, not to be addressed here. What could be the result of the paradox? What could be that result? Another question is on the search for identity. Is the search of identity now, or should the search of identity have been done when it also signed as a signatory the ECT? So the European states signed the ECT, but also the European Commission. Question: can now lack of consent be argued? But this is a question somehow rhetorical. I want to go beyond that, and this is connected in many ways to one of the arguments that has been put out there in terms of the ECT must be terminated because it is a impeding block for protection of the climate system and for protection and for a harmonious transition into the climate change that we need. Some figures have been provided. Critics say that there might be 360 billion improbable demands for compensation as a consequence of the state regulation to curb the supply of fossil fuels. That's one question, and I know, Sirshar, you've been thinking about that. I have a follow-up question after that, but let's start with it.
Right. Okay. Well, first of all, I think I'm mic'd up, so I'm good. I think we've got a PowerPoint coming up, hopefully. Yes. Okay. Sorry, PwC partner, so I'm going to have a PowerPoint, so that's how I roll. Thank you very much. First of all, I'd like to say thank you to José Antonio and the Washington Arbitration Update team for the invitation. Very happy to be involved with this again, so thank you for that. And David and DLA for the hosting, so that is fantastic facilities here, so it's nice to be here, and I hope to be coming again as well, so thank you very much. So look, I'm fascinated by these, I don't know if you call it a debate, perspectives. To me it sounded like a debate, but anyway, I'm sure they won't say that. To the more straightforward area of quantum. Very straightforward, easy, it's numbers, and that's okay. So what I'm going to do here is Professor Kovács, he sent through an article in relation to 360 billion questions. So, and I will come back to him in terms of what it is, and in terms of how I see it from a valuation perspective. Second, I'd be looking at the critical role of forcibility in determining recoverable quantum, specifically in terms of regulatory signals, and I'll come back to why it's relevant to me, not from a legal perspective, and I'm sure everyone has their views about that. And third, I will, if there's time, I will sort of look at the practical valuation methodologies as well. So I'm conscious about time as well, so maybe there was other questions, but I'll focus on the 360 billion question. Right. So this has become a central talking point in the policy debate, but warrants careful examination from the valuation perspective. This is basically an aggregation, or the theoretical aggregation of every conceivable claim that could be brought. It is not a projection of probable awards, and it does not reflect tribunals' actual awarding. This is important to comment upon, yeah? Because obviously, hey, what am I going to do? I'm going to critique this. That's what I did. So let's maybe take some data points, first of all. When I was looking at statistics around ECT, and by the way, there's lots of statistics around ECT in terms of awards and damages, they range from a ratio award of 10% being awarded compared to what was claimed to 95%. If I look at other studies, there was a 2021 International Institute for Sustainable Development that analyzed trends in investor-state disputes. The average claim was $1.4 billion compared to an award of $0.6 billion. So 43% roughly in those statistics when we're talking about averages. And to date, there's been 83 billion awarded in fossil fuel investors. By the way, not all of them deal with this agenda, could be a bit wider. So we have to be careful about statistics and how they're presented. So I should always be challenged on these things. So just bear that in mind. I'll also give a plug for the PwC damages survey, which has recently coming out, where we looked at investment treaty cases, 208 awards over from 1990 to 2025. The comparison is more in the fact a lot of them, 40% of the overall number of those awards were energy sector, and the last 5 years, 45% were in relation to energy, especially in relation to the Spain ECT cases. That's sort of skewing the volume that we're having. Conclusion there was about 41% in terms of what was claimed against what was awarded in our survey of claimants. So in practice, most claims settle for less than the amount. The amount settled for is less than the amount claimed. The awards typically fall below what the claimant wanted. Not surprisingly. More fundamentally, proper valuation methodology already incorporates regulatory risk. It does not. You're not assuming a static regulatory environment. So maybe let's sort of carry on that logic. It's more consequential for the quantum in relation to climate-related claims, foreseeability. It's not merely a legal threshold, it's a valuation view and a perspective. It directly determines the amount of loss. So, for example, the debate in relation to climate change has been running for a number of years. So we've had the carbon-intensive assets made after Paris Agreement, after years for zero commitments, and after multiple jurisdictions announced, a reasonable investor at a certain point in time could not credibly expect a static regulatory environment. It has to be changing. You're aware it could be changing. The implications from a valuation perspective are, in a but-for world, and I'm assuming everyone understands it, but maybe I'll explain that we produce a counterfactual in a loss of profits assessment. What the world would have been but for this breach, or alleged breach, against what actually happened, and what is the difference. In a counterfactual, it must reflect the declining demand. It must reflect how you project the industry. It must reflect what would have happened. So therefore, the regulatory change had happened, you need to reflect it in the numbers. This is not actually controversial. It sort of said that's what needs to be looked at. Now, everyone will debate amongst valuation experts or damages experts the extent of that risk and the extent of the discount to that. Yes, there will be a debate around that, but there needs to be a reduction for that. And obviously, over the years, we've had various regulatory signals on that point, which then shows that there's various changes in view. And by the way, this continues to today, obviously with changes in geopolitical views. That will also impact. So all of this takes a view about legitimate expectation at a certain point in time and how these assets would have been valued. And this should be always factored in. And this sort of comes back to the main point when we are assessing from a valuation perspective the standard approaches. I mentioned the DCF, which is a discounted cash flow. We are creating a but-for scenario, which incorporates this regulatory risk. It's not the only way of looking at it. You're also looking at market comparisons. This is usually a good cross-check to the primary method about how, what is it that the market is assessing and how comparable companies are valuing themselves. And the floor is always the asset base in terms of what the sunk cost would be. Jose Antonio, I'm very conscious about time. So maybe I'll just stop there and hopefully that's answered the question you asked.
Well, very, very specific. This reminder, very specific. We have, this study presupposes a potential sort of notion of regulatory effect, including regulatory chill, that would impede somehow regulations that are aligned towards protecting climate. And I wonder, and this is pure curiosity, I wonder how, or perhaps whether, I wonder whether that study took into account the solar panel Spanish cases, because those were precisely by many the opposite in terms of being subsidies to foster green energies. So I wonder how the study took that into account and if it took it into account or not.
Well, first of all, I'm not sure this is a study. I think this is just perspective.
Perspectives,
I think I was hearing that a lot. So I was also provided a perspective from a valuations view. I would a little bit nuance the solar cases to the other general climate change and reduction in fossil fuel. These are different types of cases. With the solar cases, which I've been involved with, that's a matter at a certain point in time. There's a legitimate expectation at the time of the investment of what the regime was and the amount of profits and subsidies available. Then at a certain point in time, it became more of a affordability. I remember at a certain point in time, it was super profits were being made on a lot of these projects because of pricing of solar panels and how it was set up. And it was quite a generous, I mean, we can argue about generous or super profits, and I'm sure investors will say that was the expectation, so deliver, or the respondent state would say, no, that was not the case, and therefore we've had to reduce it. So I see it a little bit differently, as not quite exactly climate change. A specific law was set out, and I think the states and various states have had the same types of cases, have argued it in a certain way about then the ability to then change the legislation. So either you could say you're course correcting it, but investors are saying they would have invested. So I see it a little bit differently from a general climate change agenda, more about specific regulatory legislation and the ability to change it.
But still fostering green energy.
Yeah. That's the main undercurrent. That's why it's dangerous in all these fossil fuel statistics. And maybe you were mentioning to me earlier, maybe there needs to be a more deeper study into it. And I agree, there probably does need to be, because those fossil fuel cases, they're varied and have different nuances within them.
Well, that precision is very useful. Let me move forward, and I think that Professor Leaua was referring to perhaps the creation of a new paradigm, or I think that at this stage we have gone from very principle-based debate, and I want to go into a more sort of where are we, or what could be the solutions now. And I would like to start with you, Sirshar, in terms of the reality is that we are in a system. If you situate yourself within the EU only, then investors, for those cases, or for those cases where they have chosen as seat of arbitration a EU member state, you may be in a situation where enforcement and execution of an award may be very difficult. So what are the options that exist nowadays if we have an intra-EU dispute in terms of damages? What are the options? So one option was international investment awards, either ICSID or UNCITRAL, etc. But since that might not be an option within the EU system for investors of the EU that sue, what are the options in terms of quantification, other types of awards? Have you looked into, for instance, a comparison between what would be done within the EU and not in investor state arbitration, but within the EU, judges, etc.? Are two questions. One, are the principles that you apply in quantum the same? And the more interesting question, if that is yes, are the results the same?
Okay, I've got another more presentation for you. And maybe what I'll do is just focus this on this slide. It's a bit busy, but maybe I'll sort of try and work you all through it. Maybe I'll start with the simple answer to the question. The simple answer to the question from a valuation perspective is we would end up valuing it the same way. However, what happens is the legal interpretation in the various jurisdictions about how they see it. And so in fact, I will allow my panelists to keep me very honest, because I'm going to touch on legal points. This is very dangerous.
And let me interject for 1 second. If you have, just to make it very concrete, if you have an award under ICSID or UNCITRAL, is the quantum generally higher than you would see in local courts, or is it the opposite way?
I think we all know the answer.
Yeah, but
it's going to be higher in the investment treaty. It's going to be higher in the arbitration, international arbitration settings compared to local courts and compared to other sort of European courts, human rights sort of jurisdictions. Is the simple answer, because I like to keep it simple as well. So thank you for that. I will try and go through this sort of briefly. It's on the slide, but this table sort of sets out the key differences in compensation standards across three principal areas: intra-EU investment treaty, arbitration. I'm going to focus on a few points. First, the governing standard matters a lot. Under the international arbitration, usually quoting causa factori, principle aims to place the investor back in the position they would have been absent the wrongful act. This is fundamentally different to the objective of the European Court of Human Rights, which is just satisfaction standard, which is discretionary and need not equal fair market value. And I've also seen that from personal experience as well. We may go in with the same logic, but the award is a lot lower, and therefore, not surprisingly, lawyers are usually deciding to advise their clients not to go through that mechanism. So but you guys will comment, I'm sure, on that. Second, on methodology, investment treaty tribunals expect to engage in a detailed expert valuation evidence with DCF models and all that discussion and cross-examination that goes on in an arbitration setting. European Court of Human Rights, I usually send a report, and I don't need to go there. They look at it and they will come up with their own number anyway. Third, lost profits, these standards, components of a DCF claim, but very seldom we see them in European Court of Human Rights settlements. It tends to be prefer compensation for pecuniary loss that is already crystallized rather than projected future income streams. Maybe the comparison with domestic levels, and by the way, huge caveat, domestic levels is wide-ranging. And I'm sure everyone has a view about domestic levels and how they're treated. And I'll just give the example of Czech law. Not that because I'm a Czech lawyer, but just so I'm in the Czech Republic, and I just thought I'd bring it out. It reflects that the same underlying compensatory principles as international law, so it does allow for it, full reparation based on restoring claimant to the but-for position. However, it applies a more conservative, causation-anchored and foreseeability disciplined approach to quantification, particularly in relation to looking forward profits. It'll be much more careful on it. Now, I'm sure everyone has a view on it around local courts and how it is and how it manifests itself, but there are a few things within the process as well need to be considered. Number one, around you're dealing with a different judge compared to arbitrator's perspective. Usually you have court-appointed experts who the judge will be relying upon in local courts. They may be acquainted, they may not be acquainted, and jurisdictions are different, courts are different, judges are different, so I'm not hopefully saying anything bad against anybody, but it's just the process and how it's seen and how it's perceived, and whether you come to the right number or not, but right number depends on which side of the fence you're sitting as well. On temporary restrictions, this is the point that connects directly to, I'll be commenting on it if I have time, Jose Antonio. Arbitral tribunals compensate for temporary interference. European Court of Human Rights do so where duration and severity cross a threshold. In domestic legal systems, some of them, they don't have such a measure, and some of them do. Finally, on review of investment treaty awards, face value, they narrowly, there's procedural challenge on investment treaties, whereas domestic courts can be full appeal and review, but that's something we all know. So I don't know, do I have a few minutes longer, or you? 1 minute. Okay, let me put another slide on, hey? Okay, so maybe just talk about an example of a type of concrete example, just to bring it home. So starting with investment treaty arbitration, and I use the example of Metalclad against Mexico, the tribunal found that a combination of municipal actions refusing a construction permit and declaring an ecological zone amounted to creeping expropriation. In this case, there was no formal taking, so it's more about a short-term restriction on the asset. Tribunal awarded 16.7 million based on DCF valuation at fair market value. That was that case. European Court of Human Rights, they had a Sporrong v Sweden as an example I've given, where 23-year-old construction ban was found to violate right to property, but compensation was determined through the court's equitable assessment. Even though there was a detailed financial model provided, and the quantum provided was materially lower than a DCF in that case. In the domestic courts, and I know this isn't talking to Professor Kovács, or communicating about, say, Hungarian law, which I'm not familiar with, certainly there can be no compensation in relation to some of those temporary injunctions. I know in some other countries there may be that level, and I know that some other cases we're looking at where you can look at it, but therefore the numbers can be lower, going back to your which is high, which is lower in terms of the compensation received. Maybe I'll stop there, because I know you're itching to move on.
That's very useful, Sirshar. Let me turn back to Professor Leaua. I would like to ask about the exhaustion of local remedies, because if we're in only EU setting, that it may be a requirement, and walk us through your thoughts in terms of, is this an effective new paradigm, the one that they're going to that EU investors may have to go through to use certain judicial systems, especially when comparing the possibilities that foreign investor may still have to submit claims of arbitration before international tribunals. Say, for instance, I don't know, Belgium being sued by Chinese investors in the banking system?
First of all, I would say that they are, at this moment, sometimes strategic options that investors may wish to consider in parallel, unless it is a fork in the road situation in the treaty, the bilateral treaty. I mean, if I'm taking, theoretically speaking, the best position possible is to cover all possible options, not to choose one.
Mhm.
If you think in terms of feasibility, obviously you choose the best in terms of your case. It's also relevant big investor, small investor, because very few people in terms of quantum put both elements on the paper, which is the cost of an investment arbitration and the damage that you may be awarded at the end of the case, and the risk that you have to pay the cost of the arbitration of the other party. I mean, the counsel fees and everything else, which may be, for small claims, really problematic. So if we think about small investors, sometimes the paradigm, it's not just, in terms of how much time you have with the local courts, but how much money, time is money, how much money you can invest into an investment arbitration so that to have real access to that kind of option. That's one thing. So parallel may be option. Choosing the longer option, let's say in terms of time, may be another option. And also whether it is a longer time or not, it's relative. There are investment arbitrations who are taking more the exhaustion than the exhaustion of the local remedies plus the European Court of Human Rights. And although they are rare, they are not excluded. So one may wish to make an assessment on case-by-case basis. And at the end, my last remark on this situation is the following. There is also another option, which is out of the paradigm either or. So because the paradigm either or is for the investor who somehow is forced to be European only. But the other option that I have seen in practice a lot is the restructuring of the business structure in a triangular way. So moving out of EU to turn back in EU in a triangular option in which it becomes a foreign investor extra-EU to come back to European Union as a foreign investor extra-EU and not intra-EU. And this is happening in practice. So how investors are acting in such a situation, it's very diverse. And what they assess is not only European Court of Human Rights or investment arbitration, sometimes they react business-wise in order to create a possibility that otherwise is not possible. And the cost issue, again, it's sometimes the criteria that they choose. If it is more costly to move outside EU, to turn back in EU as a foreign investor, or to stay within EU and move on one option or the other. Last but not least, still going on finances, I suspect that it will become quite a type of business analysis, line of business, let's say, to compare costs before a dispute on the various options. And that would be a niche in which I can see a lot of work, because it is basically what the choice is made based on, what the choice is based on, not necessarily on legal options, but on time plus money combination.
Okay, thank you. I mean, yeah, very, very practical. Now, one question for you, David, to think about, not to answer yet, on investment structuring. Now, how is investment structuring being affected by this competing of supra-international law or regional law or domestic law versus international law? Sort of, is that changing? And one for Jadranka is also on the solutions or on the developments. Do you think that all this might be further complicated by the fact that there's that some say that the solution or the way out might be to forget about treaty investment arbitration and embrace contract investment arbitration? Is that a solution? Could it be? So who wants to go first?
I could go first.
Okay.
Or do you want to go first? Thank you. So first of all, it's very interesting that you brought in the international versus domestic perspective to this issue, because now we can talk about just the ECT's perspective, and that's important because getting back to the changing world order, find increasingly that there is an increasing level of government intervention. So, to tell you the truth, there are a lot of clients who are globally, I'm not talking about Hungary, although it's quite relevant. They come and ask, okay, so like, how do you prepare for that? And increasingly, what we advise to them is, and I actually, I've been invited to talk about this to a completely non-legal forum, a diplomatic one recently, that, because of the level and harshness of government intervention, structuring decisions have to become part of the preemptive strategic business thinking, because previously you were concerned about tax, maybe you were concerned about legal regimes, and maybe you just checked casually whether there's a bilateral investment treaty, or is this state where I'm going to put a factory in part of a multilateral whatever instrument. But now they really think, and increasingly the larger the company is, the more incentive there is to do this. They're looking at it, and it's part of their initial investment strategy. And also, they look at it not only from the micro perspective, meaning that they're looking at it at the given new country level where they want to enter into the new market level, but they also view it holistically from the entire group's perspective. Increasingly, we've seen Danish companies now are facing extreme pressure on various fronts, even in the Western world, not only in Russia, which we've seen 2 cases very recently. Okay, so how do you structure? And that's important, because you can structure, of course, you're free to do that. Even if you're invested already, you can like put a holding company on top. It's cool, but the problem is, there are certain issues tribunals are going to be looking at, and they're going to be testing this, and they're going to be worried about, when, how, what you did. So basically, there is a legitimate nationality planning perspective. Tribunals recognize this. You have the right to do that. But what is important is when you do it and what is the purpose. And they're going to look at factors like timing of the restructuring, the existence or the foreseeability of the dispute. And here I would just mention this for the quantum issue, because one thing to find liability. Yes, treaty is breached. No, treaty is not breached. But how much damages you award to that also connects. So foreseeability is a dual thing. You examine it in 2 points, in 2 different stages of your decision making when you exercise your decision making as a tribunal powers. You look at the economic substance. Is there a true supporting factor to this? And of course, the overarching principle is the of the good faith. So basically, most tribunals, what they come to is, and I think the first one was the Phoenix Action versus Czech Republic case. It's an ICSID case from, I think it was, the award was issued sometime around 2009, where they really looked at abusive, whether this was an abusive manipulation or not. And the tribunal said the rearrangement of assets within a family to gain access to ICSID jurisdiction to which the initial investor was not entitled is no-go. So basically, if you already have a very strong foreseeability of a dispute, then the restructuring is not gonna work. and it's not going to pass the muster of the tribunal's examination. Essentially, I mean, I would stop there just for the interest of time. There's a specific ECT context. I think right now, just in short, most ECT clients are just going to stay where they are because they know that their 20 years are kicking, and if they're there, they're protected. And because many tribunals that are outside of the realm of the European Union, and even non-state tribunals like the Stockholm Chamber of Commerce can do that because they have a new regime to that end from 2024. They're gonna find a way to assert jurisdiction. The question is, when you're thinking about, adding something to that already existing investment, doubling down on a country, now that's a difficult situation because that's not an existing investment, and there you have to, really look into that.
Thank you.
I'm done.
Yes, and as you say, a lot of this is must be guided by the principle of faith. Jadranka, so how do you think about solutions and there's a big movement, especially by some arbitration centers, and especially ICC has been big on promoting now contract investment arbitration, but other arbitration centers such as ICSID are looking at it. There's been studies being drafted or already drafted on this. Is it a solution for Europe? Are we moving there, or are we just making additional basis for claims? Well, not additional, because you have the investment laws and contracts. What are your thoughts on that?
Right.
Conclude, yeah.
So let me just start by saying that before there was a BIT boom, there were concession agreements, state contracts, international arbitration clauses within investment agreements. What I'm trying to say is I'm not suggesting we are necessarily going back to 1970s, but I do want to offer 3 quick points as to the change or change in direction that we're seeing. So first, commercial arbitration, contract-based arbitration is not a substitute for investment treaty arbitration and protection. So what we are seeing as a result of all these developments that have been discussed is that there will be an increased focus on contractual tools to manage regulatory risk. And that will inevitably put greater emphasis on drafting of stabilization clauses, drafting of change in law provisions, of international arbitration clauses. The second point, by such greater reliance on contractual arbitration, we will necessarily see change in the nature of disputes. So instead of litigating the scope of treaty protections, we'll be litigating the meaning and operation of contractual risk allocation mechanisms, and that's especially with long-term energy and infrastructure projects. And then just to synthesize some of the words that have been shared by my esteemed co-panelists, David, you used, I like the phrase, fragmentation is going to get worse. And I want to continue that by saying, yes, it's going to get worse before it gets better. But just, by going back to, back in history, when the resurgence of BAT first came to be, and I actually will use that as well, like some of the clickbait titles, like ISDS in EU is dead. I'm not so persuaded by it, and I would not be so dramatic about it. I don't think that ISDS in EU is dead. I just see it as something that's going through a period of change, and as history has taught us, life is cyclical, and so is law. Law is very much alive. So what we've seen so far through ISDS is that all these treaty protections have been granted. So now, instead of them being granted, parties will need to negotiate it, and that's the biggest difference. That the rights are going to be what you agree on and what you negotiate. And then the last point is that we are currently also seeing a new generation of BITs, and so perhaps in the next 10 to 20 years, we'll be seeing a greater number of contract-based arbitrations, and then in 10, 20, 30 years, we'll get back to greater number of ISDS cases under the new generation of treaties. So I see it as a cyclical rather than dramatic or disappearing.
Really hope that in the next 2 years we just go out of the cycle in geopolitics, but that's another story. Well, we've come to the end of our panel, and the only regret that I have is that normally we would have given you. We're coming to the end of our panel, and the only regret that I have is that normally we would have given you the floor to ask questions, but we have another panel, so that will be limited. So please join me and give a round of applause to our panelists, because I think that they were brilliant.